Thank you, Mr. Chairman. As I think the panel knows well, we have a whole series of votes going on right now, and I ran over to cast two. He's going to go cast one, and I'm going to go, right. And these are only 10-minute spreads between votes. So let me just make two more points, if I might ask questions, and then if you'll forgive me, I'm going to conclude as well, because we're going to be on to the third vote in a second. By the way, an odd story, artifact. When recruited and asked whether I was willing to run for the Senate, the person doing so spent 20 minutes talking at me about what I should care about, and then finally took a breath and said, well, what are the issues that would motivate you? And my first answer was ending PTO fee diversion. I was greeted with a shocked silence, and I said, no, that's a winner in Delaware. There's a lot of people concerned about this. This was my first introduction to how badly out of touch I was with what moves the average American. But what is encouraging here is that in an otherwise fairly divided panel, there is broad unanimity about the importance of making sure, right? I mean, because who doesn't want higher quality patents, right? I mean, what I think we're disagreeing over, to the extent we are, is just about what are the most efficient and appropriate mechanisms for reducing the number of improvidently granted patents, for re-examining or invalidating those that are flawed, and strengthening the rights of the holders of patents that are legitimate patents and should be defended and protected. And if we can balance that better, we should be able to achieve a better ecosystem for innovation. So strengthening the Patent and Trademark Office by giving them the power to end fee diversion struck me as one important piece of that, which at least it's clear here we have some agreement on. Another, in terms of addressing the bad actors that were in many ways the dominant focus of a narrative of a few years ago. One of the provisions in the Stronger Patents Act grants the FTC authority to target abusive assertions of patent rights. I'd be interested in anyone who thinks that's a bad idea. Professor Cotter.
I don't think it's a bad idea. If I read the bill correctly, though, I think it would also preempt the state attorneys general from using the state counterparts to do the same thing, and I'm not sure if that is necessarily a good idea. The FTC, like the PTO or any federal agency, has a limited budget, limited ability to decide what its priorities are. I think Correct. It might actually be better to leave this to the states. Not necessarily take it away from the FTC, but...
You make a good point. What may not be known to you is I'm the ranking appropriator on the subcommittee that funds the FTC. And let's just say strengthening their ability to do things like this to prevent abusive patent demand letters and so forth is also a priority of mine that I think is in the interest of the system broadly. And I know relatively few, if any, players who think that strengthening FTC authority and funding in this area is a bad idea. Let me close. Mr. Diddy, I just wanted to ask you about, in that previous exchange about injunctive relief, how does the post-eBay lack of injunctive relief and the risk of PTAB challenges, which is the other sort of main component of Stronger Patents, affect business decisions about investing in new research and product development? How does this environment impact your sense of the investment decisions made by InterDigital, but many other companies that invest in R&D?
Sure, thank you, Senator. As I mentioned earlier, I think that both the eBay decision and repetitive challenges and exposure to patents in duplicative venues through PTAB reviews creates an inefficiency and delays in negotiating license agreements, which our company makes a majority of our revenue through monetizing our product, which is innovation, through license agreements with other companies. That delay to revenue really affects our ability to predict what resources will be available to us and how we can fund other projects. Now we have funded and continue to develop 2G, 3G, 4G, and now 5G and beyond technology, and so to have a solid pipeline of innovation is critical to our business model and to our success. And having predictability in the patent system and certainty in how we can negotiate with companies and reach a result, not just have endless negotiations, is very important to that.
Well, let me close with a question, if I could. My recollection as someone who advocated for and then was involved in and is now trying to reform the American Invents Act when I was in the private sector and then and now as a senator, PTAB was a key piece of it. creating PTAB and making possible PTAB trials, the whole IPR process, was designed to provide an efficient second look at patents and whether they were appropriately granted. But, there's a range depending on your sector. Let's just say a blended rate of about 80% of PTAB's final decisions, at least some claims were held unpatentable. Is it efficient for the PTAB to repeatedly reevaluate patent claims even after an examiner and courts and PTAB panels have found them patentable? There's been a broad division of opinion about the provisions in the bill that would limit the number of challenges. Some of you think we've gone too broadly, others think it's just right. I'd be interested in hearing from each of you on that specific question about repeat PTAB reviews, whether we've missed the mark in terms of efficiency of review or whether we should leave it alone as is. Professor Cotter, and then we're going to go to Mr. Bright.
Yes.
And I'm going to run and vote.
So the 80% statistic, just that, first of all, we have to think what is the percentage of petitions that are instituted in the first place? We're talking about 80% of those that go all the way through to judgment, but a lot of them are weeded out along the way before that. So I think the actual statistic, if we take that perspective, would be smaller. But I think that it is important to preserve the ability to raise different arguments, different prior art references, different parties that may have different perspectives on the validity of an individual claim. Things can change depending on claim construction in district court litigation after a Markman hearing. So I think there are a range of valid reasons why we don't want to take away the ability of the PTAB to consider a claim that has been challenged in a previous PTAB proceeding.
And Mr. Diddy.
I think the Stronger Patents Act strikes the right balance. Interdigital has itself been exposed to duplicative examination of patents that have produced on the same patent with the same prior art different results, and that's mainly been because of the difference in claim construction standard, but the difference in presumption of validity is also a factor. And so I think harmonizing those two standards is appropriate and is the right thing to do.
Mr. Lang.
The AIA, which itself was a painstaking compromise over many years, I think it took the right approach on an issue like this, and it left a lot of discretion to the Patent Office to use its practical experience and expertise. I think overwhelmingly serial petition practice is not abusive. There are many different valid reasons for multiple petitions. You could have a single patent that targets multiple defendants. Each of one is going to try to mount their own defense. There may be situations where a single challenger may need to file a couple of petitions because they're arguing against a large number of claims in a single patent, or they have to deal with alternative claim constructions. The issue is actually quite complex, and it calls for discretion and some flexible standards, which is exactly what Director Iancu has done at the PTO and some of the recent PTAB decisions. They've looked at practical experience, they've thought about the issues, and they've developed sensible criteria. And now they've come out with a new trial practice guide that gives the petitioner and requires the petitioner to explain why multiple petitions might be necessary in a particular case. I think continuing to allow that discretion and flexibility and growth with experience is the right approach, rather than the so-called one-and-done approach that's in the bill.
Is it legitimate to have a concern that some of the ways in which Director Iancu has used that discretion to improve, focus, narrow the practice, that those are susceptible to revision or reversal by the next Patent and Trademark Office director? And so those that can achieve broad support and consensus should be done as a statutory revision?
Well, I think that we're going to continue to learn. A lot of the changes are quite new, including the claim construction change is less than a year old. The amendment pilot program has barely begun, and with serial petitions as well. I think that we're going to continue to gain experience and expertise, and it's going to require continued refinement to have a fair procedure.
Professor Moss.
Well, I think you will be surprised to hear that I think that the Stronger Patents Act achieves the proper balance in ensuring that an administrative agency respects basic precepts of the rule of law and the protections of the constitutional rights, particularly due process rights of owners of legal property rights. Patents are vested property rights once they issue by the Patent Office. They're property rights by statute. And as such, this has been a key to the U.S. patent system from the beginning. They have served as foundational interests in driving venture capital and driving investment. And Elias Howe sold an interest in his patent in the lock stitch in the sewing machine in 1850 so he could fund his infringement lawsuit against Isaac Singer. He was only able to do that because it was a property interest that he could use as a collateral for obtaining the litigation financing for his lawsuit. He would be accused now by Mr. Lang as being an MPE because he was not manufacturing of having funded a lawsuit against a manufacturer. So what the problem you have at the PTAB is this essentially double jeopardy for patent owners. They never have any certainty. Their property rights are never vested. And you have ultimately what property lawyers call cloud on the title, which completely diminishes the ability of innovators to use their patents to make not only R&D decisions for investing billions of dollars, but for individual inventors and startups to obtain venture capital financing. I'll also note that the statistics on the serial petitions and some recent empirical studies that will be hopefully coming out soon show that actually it is a serious problem with a lot of abuse. I was part of a presentation at the USPTO a couple years ago. A significant number of the serial petitions are duplicative serial petitions. And what is even more shocking is that the statistics show that even with these duplicative serial petitions, so they're almost identical to the prior petitions, the chances of them being granted go up. That's not the rule of law. When the exact same arguments are being made and you just keep refiling and eventually you actually get a petition instituted. And so this is a serious problem and it needs to be addressed. And it needs to be addressed as we would address any other government institution that isn't using its discretionary authority to violate basic rules of law and the due process rights of citizens.
Thank you. Mr. Lando?
I think that Director Iancu's new rules have to have some time to work out. We've seen with the AIA that statutory text sometimes doesn't quite mean what we intended or thought it might have meant.
I'm clear on that. Yeah.
Codifying that now before we've seen what the outcome of these new changes are going to be doesn't give us time to see how we might need to adapt the existing regulation, rather. Beyond that, I know you have to vote, so be brief. I concur very much with what Professor Cotter and Mr. Lang said.
Mr. Bright, bring us home if you would.
Yeah, so it's not efficient. It does not take multiple IPR reviews and district court litigation analysis to take out a bad patent. But it is very possible to use multiple IPR reviews and to use district court litigation to take out a startup. And so I think that we need to return to what the original intent was, which was to limit it to just taking out in an efficient way an alternative to litigation. And I think the Stronger Patents Act makes that language clear. And more importantly, I think that it also will encourage the ability for universities to license to small companies because they actually will be able to look at something, evaluate it early on, and say, we can eventually establish clear title with respect to this.
Thank you. Wonderfully efficient. Gentlemen, thank you very much for your testimony. As the chairman has said, he'll keep the record open for a week. There may be some additional questions for the record. I certainly had a few we didn't get to, and there were a number of committee members interested in the topic, but who are voting at the moment. So thank you for your time, for your understanding, and for the clear explication of your competing views on the wisdom of this piece of legislation. Thank you very much.